This is a quick take produced by American Bankruptcy Institute. I am ABI's editor-at-large, Bill Rochelle. We're coming to you from ABI's annual spring meeting in Washington, D.C. My guest is Rich Levin, the co-chair of the Bankruptcy and Reorganization Group at Jenner & Block from that firm's New York office. Rich is doing double duty here at the spring meeting. He's on leading two panels, and indeed was chairing the very first panel on the greatest, most important bankruptcy cases of all time. Unfortunately, Rich didn't get to tell us what his favorite case is because he was just heading that panel. So this is your chance, Rich. What is your vote for the most important bankruptcy case of all time?
My vote is for local loan against Hunt, a 1933 Supreme Court decision that is the foundation of all modern bankruptcy law. It reaffirmed the importance of the fresh start in bankruptcy, and although it is not cited much, it is the underpinnings of the discharge, the effect of the discharge, the breadth of the discharge, and Congress relied very heavily on what local loan had to say about the honest but unfortunate debtor and the need for a discharge when it enacted the Bankruptcy Code in 1978.
Well, let me ask you this, Rich. As they so often do now, did the Supreme Court back in the 1930s garner these results by a tortured analysis of the statute?
No, actually, the Supreme Court didn't rely so much on the statute at all. Of course, at the time it was under the Bankruptcy Act, not the Code, and the Act spoke in much broader strokes than the Code does, which is a little more focused in its drafting. But the Act provided for a discharge. Mr. Hunt had filed bankruptcy after having given a wage assignment to his creditor, local loan, to secure his repayment of a $300 loan that he took out about 6 months before he filed bankruptcy. After bankruptcy, the creditor sought to enforce the loan in Illinois State Court by garnishing, enforce the assignment of wages by garnishing the wages from Mr. Hunt's employer.
And this was after he'd gotten a discharge.
After he'd gotten his discharge. Hunt went back to the bankruptcy court and asked for enforcement of the discharge order. It went all the way up to the Supreme Court, who held that the bankruptcy court, important principles today, the bankruptcy court has jurisdiction to enforce its own orders. That the bankruptcy discharge, as a federal law, takes priority and preempts state laws that would interfere with the discharge. And most importantly, that an assignment of future wages is a fundamental impairment of the nature of the discharge, because, as the court said, a debtor who is earning only for his creditors might as well not be earning at all, and therefore really doesn't get released from his debts by the discharge.
Well, my goodness, it sounds like that really is a case that is, I guess you could say, the underpinning for our modern notions of bankruptcy.
That's why I said that. Yeah.
And it is odd, because you're right, it is not cited that often.
It's not cited that often, and as you asked a moment ago, and maybe I didn't make clear enough, the court did not rely on any provision of the Bankruptcy Code other than the discharge in general and an interpretation of how broadly the discharge should be interpreted. It also relied on the fact that the Bankruptcy Court was a court of equity. This is another case where the Supreme Court has said that, and said equitable principles do not permit enforcement of the wage assignment after the discharge.
Well, let me tell you this. This was, what, 80-something years ago now?
Years ago, right.
85 years ago. Are any of the principles of local loan versus Hunt under attack these days?
Yes, there's what I consider to be a very important and very wrong decision out of the 11th Circuit from December of last year, December 2017, called Title Max against Northington, in re Wilbur, where the debtor had gone to a pawnbroker and pawned his car for a loan. And under Georgia law, if the debtor did not redeem the pledge, the pawnbroker could give notice And after 30 days, if the debtor didn't redeem within the 30-day period, title would automatically vest in the pawnbroker. The pawnbroker would become the owner without foreclosure proceedings, without anything more than that. The debtor, not being on top of things as debtors often are not, waited until about 28 days into that 30-day period to file his Chapter 13 case. He filed the Chapter 13 case, sought confirmation of a plan that treated the pawnbroker as a secured creditor. The pawnbroker argued, after confirmation, that the Georgia statute defined the debtor's property right under United States against Butner, and that the property right vested, the ownership vested in the pawnbroker after that 30-day period expired, as extended by Section 108, the 60-day extension in Section 108.
And of course, what they didn't argue was that Butner was modified in 1992 by Barnhill, which tells us, among other things, that although state law is the basis for your property rights, bankruptcy law federal law determines when a transfer takes place.
That's right.
That seemed to have been an issue that was ignored.
It was. The other
Wilbur.
issue that was ignored in Wilbur was, Butner says, we look to state law unless a federal interest requires otherwise, and certainly bankruptcy law is a federal interest that should require otherwise in determining whether the debtor gets to keep his car and get to work. In any event, the 11th Circuit held that the Georgia title vesting statute trumped the bankruptcy law and denied the debtor his car, even though the plan had been confirmed, providing for the car loan to be treated as a secured loan.
Rich, was that a unanimous decision in the 11th Circuit?
No, it was a 2-to-1 decision. There was a vigorous dissent. There was a motion for rehearing on bank, which surprisingly was denied.
Yeah, it surprised me too.
And I have the sense that the pawn industry throughout the country is going to try to propagate that ruling through the other circuits.
Is there anything in that ruling, in that opinion, that may limit its applicability in other cases, perhaps even into Chapter 11 cases?
Well, the fact that the debtor filed late in the 30-day period, or at any time in that 30-day redemption period, is going to be an important fact. If the debtor can file before then, before that clock starts ticking at all, the automatic stay will prevent the creditor from starting the clock to accomplish the title transfer. That's an important distinction.
And also the majority opinion written by newly appointed Judge Newsom said that the result turned upon the unusual facts of the case.
Yeah, I didn't see anything unusual about it.
Well, neither did I, but that's what he said.
Yeah.
And it does give later courts an ability to distinguish it based upon that fact.
Although my experience when courts say this is a very unusual case, we're not setting a broad precedent, it gets cited
anyway,
and it does in fact establish a broad precedent. So
well,
we'll see
I'm afraid you're exactly right about that, Rich. Well, this is very interesting. This shows you how law from 85 years ago can sort of slyly come under attack in later years by different judges.
And I'm concerned, not just in the consumer area and the pawn area, but generally in the treatment of secured credit for consumers and for businesses. If this decision is good law, I can imagine state legislatures at the urging of secured lenders revising the foreclosure laws to provide that there won't be any foreclosures, that if there's a default, title will simply vest in the creditor, preventing any form of bankruptcy reorganization under Chapter 13 or under Chapter 11
well,
for that.
I got to say you're absolutely correct, Rich, because that's really the door that opinion opens. Yeah. Well, listen, thank you very much, and we thank you for your time, and let's hope that the Wilbur decision does not propagate itself.
Thank
Good
you,
day.
Bill. Good to talk to you.